All right, we are live. If you are driving home in some rush hour traffic, turn the volume up. We have a very special guest today, Rick Lutzel with Lutzel Broadway and Associates. He is a real estate attorney, and we're not actually going to talk about real estate. It's real estate related, but wills and trusts and estates. I know it's something y'all think about doing, but we're just too busy to do it. So we're just going to jump right in and get Rick. Hey, Rick, how you doing today?
Hi, Danielle. How are you?
Good. So the $1 million question, do I need a will or a trust? How does somebody know that's something they need?
Well, easy to answer. Yes, you absolutely do. Everybody does. If you don't, we're going to leave it up to the state to decide who and when your assets, to whom and when your assets are distributed. So just kind of an overview, an estate is really everything you own, all of your assets, whether they are liquid assets, real property, personal belongings, anything you own is considered your estate. So you have the right to determine who receives your assets, your estate, if something were to happen to you. But if you do nothing, the state's going to decide. And that rarely is the better option.
So is there a difference between a will and a trust?
Significant difference. And let me kind of start from the beginning. If you were to pass away, and the explanation I'm going to give you really applies not just for North Carolina, certainly for South Carolina as well, and really almost all 50 states have consistent laws when it comes to estates and administration of an estate. If you were to pass away with no documentation, without a will or a trust, your estate is going to go through what's called an intestate distribution. Intestate is a Latin term that simply means without a will. So therefore, without a will, the state courts have to defer to state law in deciding who gets your assets. So without a will, an intestate distribution is going to follow a bloodline distribution. So all of your relatives, your nearest living relative is going to receive your assets. And in a lot of cases, that's fine. But it may not, because it's not what everybody thinks it is. And I can give you plenty of examples, but just to explain how the state code is written, if I were to pass away today, my wife would share my estate with my kids. I've got 3 kids, been married for 30 years. So if there are any assets that are not jointly held between me and my wife, they're going to be distributed between my wife and my children. Not necessarily the most ideal distribution.
Right.
With a will, I can dictate how my assets are distributed. I can say, I want all of my assets to go to my wife, and then if something were to happen to both of us, then they go to my kids. But the point being is I can control it with a will. The downside to a will is, in order for my assets to be distributed, in order for any of my wishes to be carried out, my will and my inventory of assets will be presented to a court through what's called the probate process. Probate is defined as the retitling of the assets of a deceased person into the name of a living person. That's all probate is. It's retitling assets of a deceased person to a living person. The problem is probate is not that easy to go through. Probate is very long. It can take 6, 9, 12 months to complete. It's expensive. Court fees alone can run into the thousands of dollars. I'm not talking about attorney's fees. Attorney's fees are on top of that. Court fees alone can be a few $1,000s. But probably most significant is that probate is a public event. Anybody in the world can come in and see what you had in your estate when you passed away. And therefore, anybody in the world can come in and challenge what's in your will. Anybody can contest your will. Even if I don't really have legal standing, I can still walk into the courtroom and object to what I'm presenting to the court in my will. The court has to listen to me by law, have to give me an opportunity to be heard. So that's going to slow things down. And worst case scenario is the court agrees with whomever is coming in and challenging it. You can avoid probate with a trust. So to answer your question, the difference between a will and a trust in very simple terms is when you have a will, your assets go through the probate process. When you have a trust, you avoid probate. The way a trust works is you take all of your assets that you own in your name as an individual or jointly with your spouse, and you retitle the assets into the name of your trust while you're alive. So remember, the definition of probate is the retitling of the assets of a deceased person. Well, if you have a trust and all of your assets are in the name of your trust, there are no assets for a deceased person because they're all in the trust. That's how it avoids probate. Seems pretty simple, and it really is.
Mm-hmm.
So really all you're doing with a trust is bypassing probate. Now with a trust, you also have a lot more control over the distribution of your assets. You can really not just dictate to whom your assets are distributed, but under what terms, what circumstances. For example, I mentioned I've got 3 kids, 3 boys.
Mm-hmm.
They're all great kids, very responsible, but they're all still kind of young. And I don't want any of them getting a lump sum of money at their respective ages. Right now they're 25, 21, and 18 years old. Again, good kids, but
right.
any amount of money is going to be a lot for, especially an 18-year-old to deal with.
Mm-hmm.
So in my trust, what my wife and I have done is we've staggered the distribution. So if something were to happen to my wife and I today, my kids wouldn't get a distribution of their assets except for their daily living expenses until they turned age 25. And then another distribution at age 30 and another at 35. So those were just ages we picked out. We knew where we were in life back then.
Right.
So we decided they were going to be favorable. You can tie a distribution of assets to anything. It can be age, like I did. It can be life events, like graduating from college or graduate school, buying a house, getting married, whatever the case may be. You can accommodate all of those needs for distribution in your trust. You really can't do it as much with a will, certainly not without a will. So with the will, again, with the trust, again, you've got a lot more control over how assets are distributed. You can also restrict the distribution of assets. And unfortunately, I've had to draft this more than one time. But let's say somebody in your family has a substance abuse problem and you simply don't want them receiving a distribution. You can have a provision in your trust that says if somebody's still dealing with demons, then they're not going to get a distribution of assets. And again, I hate to say that I've had to draft that, but I have. And again, that's just something you can control.
Right.
You can also control guardianship. We didn't talk about minor children, but a significant part of a trust is planning for the care and well-being of minor children. With a trust, you can do that to a great extent. For example, I drafted a trust for a family who originated from Europe, and most of their extended family was still overseas. Well, the way they wanted to control the guardianship of their children was to have a temporary guardian named if something were to happen to them until their parents could come over from the European country, which they estimated would take probably 6 to 8 months based on visas and all the red tape that people have to go through. So my point being is with a trust, we were able to put those provisions in place, giving this family the control over the guardianship of their minor children, much more so than we could have in a will.
That makes complete sense. Now what about when should you get an estate together?
You should start doing estate planning once you start accumulating assets, or if you have a family. Remember, the benefit of estate planning is having control over the distribution of your assets and having control over the guardianship of your children. So once those things are falling into place, that's when I would recommend considering estate planning. Now, does that mean somebody who is fresh out of college with their first job should worry about a complex estate plan? Probably not. They probably don't need to at that point.
Right.
But as they start accumulating assets, and like I said, once you start having children, that's when it really becomes important. A very common misconception is estate planning, and really more specifically, trust, are only necessary when you have significant assets. People have long thought that a trust is only needed or only used by the mega wealthy, and that's simply not the case. It doesn't matter if you have $25,000 to your name or $25 million to your name. everybody should want to avoid the probate process if you can.
Here's a question. Do I need a trust if I don't have a lot of money?
No, and that's really what I was saying is it's a trust is going to save you the hassle, the headache of probate. So again, even if your estate is modest, even if you don't have a lot of liquid assets, even if you don't own real estate, but you still have personal property, the stuff that's in your house, your furniture, your car, if you have any kind of any jewelry, anything that is important to you, it's time to have a will or a trust. Again, in my opinion, a trust is better, but
Right.
you should at least have a will. And again, the reason being is you don't want the state to control who receives it. You want to have that control.
Yeah, that makes complete sense. You had mentioned earlier offline about, I guess, paying estate taxes, and how does that work? You want to touch on that?
Yes, ma'am. Great question. Estate taxes have long been a concern for many people, and there are a lot of ways you can plan to prevent estate taxes. But that said, there are some benefits that the state and federal government give us as U.S. citizens to avoid estate taxes. And the simplest is something called the unified credit. The unified credit is the amount of money you can pass to anybody before a tax is assessed. And that's through your state when you pass away. I'm not talking about gift tax, I'm talking about estate tax. So if I were to die today, I can pass a specified amount to my children or to my next door neighbor or to anybody I want before the government gives us a tax. Now, it's important to have a little bit of history on this. Way back when the first President Bush was in office, so many years ago, he's actually the one that came up with the unified credit. He was trying to eliminate the estate tax, and Congress was pushing back saying, no, we don't want to eliminate it. We use that money. We need to have an estate tax. So what he did is implement something called the unified credit, which is the amount of money, again, you can pass tax-free. Back then, it was $600,000, which sounds like a lot of money, but when you realize your estate includes your home, your cars, your savings, your investments,
Right.
you get to $600,000 pretty quickly. But that was the amount you can pass tax-free. Over the years, and I'll keep this short, but over the years, that unified credit has steadily increased with each administration, Republican and Democrat. It was irrelevant. Both were increasing it. President Trump, and again, I'm not being political, don't think I am, but President Trump increased the unified credit to $11.75 million each. That means I can pass $11.7 million to my kids, and my wife can pass $11.7 million to our kids before they pay a tax on it. Sad to say, I don't yet have $23.5 million to pass to my kids, but if I did, I can do it tax-free. Mm-hmm. So to answer the question with respect to estate taxes, yes, estate taxes do exist, but the government has put in a pretty high hurdle for us to clear before they're going to start assessing that tax.
Okay, that makes a lot of sense.
That may decrease with the new administration. There is some speculation in my industry, in our industry, that there is going to be a decrease in the unified credit. It probably will decrease from 11.75 million each, but we don't know to what. I would be very surprised if it came down too much. I think there'd be too much backlash.
Okay. Sounds amazing to think you'd have that much money to leave to somebody.
I wish I did. My kids wish I did.
I know, right? Okay. I think you just answered this. Does a trust provide any tax savings or benefits? I think that's just what we went over, right?
Well, yeah, in a way, but let me address it directly. No, a trust does not. Well, the kind of trust we're talking about. Now, I'm talking about a revocable living trust, which is used and designed primarily for estate planning. There are other types of trusts that do provide tax benefits. For example, it's something called a charitable remainder trust, which the way that works is you can contribute X amount of dollars. Let's just say, for argument's sake, I contribute $100,000 that I want to go to my charity, my favorite charity. I can put that $100,000 in what's called an irrevocable trust, which is different than what we're talking about. But an irrevocable trust will hold that money, and I will receive a tax benefit of the amount I'm donating to that charity of $100,000. Now that money will stay in the trust for as long as I say in the trust terms it should be there. And it could be a term of years, or it could be for the rest of my life. Whatever that term is, it'll stay there. While that money is in that trust, I'm earning the income off of it, not the charity. The charity gets the bulk of the money. Well, they get all the money that's in the trust. I get the income off of it. So there's a benefit to both me and the charity. And by the way, the money that I'm earning as income is not taxable either. It's tax-free. So there's a benefit. There are types of trusts that will give you a tax benefit, but what we're talking about for estate planning, it does not. But again, for estate planning purposes, for most people, the unified credit covers the tax concerns anyway.
Very interesting. So do you want to talk about power of attorneys? I know I deal with them in the real estate world, but what would you suggest as far as outside of my world, why someone would need one?
Great question again. Estate planning really includes some basic documents. We've talked about wills and trusts already, but a complete estate plan typically will include a durable power of attorney and a healthcare power of attorney. The durable power of attorney will enable somebody to sign your name or conduct your business if you are unable to do it on your own. And unable to do it on your own includes physical disability, where you simply can't sign your name, mental incapacity, where you can't sign your name, or simply being absent. If somebody that is traveling and they need somebody to pay a bill, write a check, sign a contract, whatever the case may be, a durable power of attorney will give somebody you name that authority to do that for you. A very common misconception in this state is that a spouse automatically has that authority. They do not. Now, of course, on a jointly held account, they can sign, but my wife cannot sign my name on a contract or on anything that is not jointly held without my written permission. A healthcare power of attorney may be somewhat obvious what it is. It lets somebody else make healthcare decisions for you, again, if you are unable to do it on your own. Again, that includes physical disability or mental incapacity. Healthcare powers of attorney can be very broad in scope. They can cover everything from something simple, including maybe using a new type of medical procedure or something that could potentially benefit somebody but has not yet been approved by the federal government. Or it can also include end-of-life scenarios, which obviously a drastic topic, but we can have in a healthcare power of attorney that authority. Again, they're drastic, but in my opinion, they are as valuable, if not more valuable, than some of the wills and trust documents that we're talking about.
Yeah, it's all important. So a living will. What you want to talk a little bit about that?
Sure. A living will is different than a last will and testament, not to be confused. What a living will does or is your personal direction to a doctor, to your medical professionals as to what you want to happen in certain circumstances. And you can dictate directly through the written document whether or not you want to be kept alive by artificial means or not. You can dictate if you want to be given artificial nutrition if you're unable to feed yourself or take on food. So again, it's your opportunity to convey in writing to a doctor ahead of any circumstances what you want to happen in certain circumstances. I've had many people ask me to draft them, and in my opinion, they are very valuable because what they do is, especially when it comes to end-of-life decisions, the living will takes the burden off of somebody you care about to have to make that decision. You've already made that decision, whether you do or do not want to have artificial life support offered. Then you've already made that decision, and it takes the burden off of somebody else having to do that, make that decision.
Right. So the $1 million question, how much does all this cost?
Yeah, a lot of times it'll vary depending on the complexity or how much you're doing, but overall, and the way we do it in our firm is really kind of a la carte. You tell us what you want us to draft, and we show you our flat fees. But in a nutshell, I think people can reasonably expect for a trust to pay anywhere between $700 and $1,000 for a basic trust. For a will, it's going to be a little bit less, probably about $400 for a simple will. Powers of attorney, again, depending on the complexity, I would typically expect it to be about $175 to $200 for the powers of attorney. And then living wills are usually a little bit less than that, usually 125 to 150 per an individual. Most law firms, ours included, will offer a discount if it's a married couple coming in. So it's not going to be the same price for both people. It's going to be a little bit reduced for the second.
Right.
So overall, I think if you put everything together, a living trust, durable power of attorney, healthcare power of attorney, and a living will, and there are a lot of supplemental documents that go along with them that we haven't mentioned, but you're probably looking at $1,200 to $1,500 for a complete plan.
Right.
If you're not doing a trust, if you're doing a will, it's going to be a little bit less than that, but I think you're safe in that price range.
And what I assume you can do North and South Carolina. Can you do any other states? Because I might have people watching from all over. Are there other states, or are these just the 2 states you focus on?
Well, obviously, I'm in North Carolina, but I am also licensed in South Carolina. We're also licensed in New York, DC, Alabama, Ohio, and Texas. So we can do it in all those states.
Cool. And so the good news, everybody, if you're watching this, is Rick will give 20% off if you watch this today. So just comment below. Feel free to share this to your page. It's just some really good information, and you could really be reminding someone that's had this on their to-do list for a while to get this done, because we all think it'll never happen to us, but things happen, unfortunately, right?
It's one of those things that nobody likes to think about, but it's important.
Yeah, it's important. And real quick, we're going to wrap it up. Do you want to end with, like, I don't want to use the word horror story, but do you want to end with like a story or an experience you went through just to really drive home why this is really important?
Yeah, and it really does follow up with what we were just saying. How you don't like to think about this stuff, but how important it can be. And I had somebody come in my office, and this is about a year ago, give or take. But it was the wife of a husband who had passed away, and they had been married, I want to say about 35 years. And he passed away without a will. Now they had a lot of jointly held assets. So those assets upon his passing automatically passed to his wife. She didn't have to do anything. But he also had a lot of individually held assets. He had a bank account in his name. He had automobiles in his name. In fact, they had purchased a house in South Carolina. They're North Carolina residents, but they purchased a house in South Carolina that was just in his name. She was not on the deed. And just an aside, South Carolina is not a marital rights state like North Carolina is. So it was relevant that she was not on the deed. But in any event, when he passed away without a will, his estate had to go through remember we talked about the intestate probate. So the state law of North Carolina applied. And what happened was his wife received all the assets that were jointly held, but all of the assets that were individually held were shared with their kids. Now, they had 2 kids. One of the oldest child gifted everything back to his mom. The younger child, who had kind of a strained relationship, didn't. Right. And it was a significant amount of the assets that my client, the wife, was planning on using to live. Mm-hmm. And all of those assets by law went to, and again, the younger child wasn't estranged, but he was, again, a little tougher scenario. But the point is, had this gentleman done a little bit of planning, whether it was a will or a trust, the wife would have had all of those assets that she thought she was going to have. She fully expected to have all of it. But again, without the estate planning, it went through the state intestate laws. And unfortunately, she didn't get what she thought she was going to. It was tough.
Wow.
It was tough. It was honestly kind of heartbreaking that I had to explain the laws of the state were not favorable, but they are what they are, and they can be avoided. You can avoid that stuff.
Well, hopefully somebody watching this learned something today. I know I kind of knew most of this, but some of it was a good reminder. She might be hearing from me. And so just be sure to reach out to Rick Lutzel. And if you can't reach him by all the social media, just reach out to me and I'll gladly connect you to him. And thank you so much for joining us. Appreciate it.
Thanks, Danielle. Appreciate it.
All right. Bye. Have a good night.
Bye-bye.